Adoption is a happy occasion in the lives of many families and children. If you're thinking about adopting, there are some legal matters you should be aware of. Attorney Sherry Smelly joins us on Studio 10. Sherry, good to see you again.
Nice to see you.
So first off, this topic is very personal for you.
It is.
Let's talk about that a little bit.
I am an adoptive mother. I have 3 adopted children and 2 grandchildren now. And adoption is the way that we completed our family.
So a big, happy family now.
Exactly.
So you know a lot about what we're talking about today. Let's start with jurisdiction. What court hears adoption petitions?
The probate court of the county where the adoption takes place hears adoption petitions unless it becomes necessary to terminate the rights of the biological parent. At that point, the case would be transferred to juvenile court for that limited purpose.
And who is eligible to adopt?
In Alabama, any adult, single adult, is eligible to adopt, or a married couple, which is defined as a husband and wife, man and woman. Right now.
Okay. Now, here's a unique question. We asked this, who is eligible to be adopted, but who is eligible to be adopted, as in, can adults be adopted as well?
Surprisingly, an adult can be adopted in the state of Alabama. My oldest child was 19 during our adoption. It just requires that person's consent and the consent of the 2 adopting parents.
And it can be so important to bring someone in as part of the family to complete the family.
Yes, it can, for both the children and the parents.
Definitely. All right, so who needs to give consent for an adoption?
Consent is required from any party that is over the age of 14, even if one of the children is a minor. If they're 14 or older, they must consent. The natural parent of the child and any agency that the child may have been relinquished to.
Now, you hear some stories about how this can start to be a little bit touchy sometimes. What if one of the parties denies that consent?
Then the option is for implied consent or termination of parental rights would need to be established in the court. Implied consent occurs when a parent has abandoned the children, or if they fail to comply with the punitive father registry, or if after notice and after 30 days the parent fails to appear in court. And implied consent cannot be withdrawn.
All right, well, you brought up that word withdrawn. How can someone withdraw from consent?
When a parent signs to consent to an adoption, at the bottom of the form is they can sign within 5 days to withdraw that consent by sending it to the probate court hearing the adoption. If they fail to do that within 5 days of signing the consent, or 5 days after the birth of the child, whichever comes last, then the consent may not be withdrawn.
Now, lastly here this morning, Judge Tim Russell in Baldwin County uses a term, happy court. What's that?
He calls it happy court because we get to see families come together. I have served in that court as a guardian ad litem on many occasions, and it's wonderful to see these families come together. Many times as judges and attorneys, when you come to see us, it's not a positive thing. This is one area that is very enjoyable to be a part of and to see and to touch people's lives. So.
And if you're thinking about adopting and have any of these legal questions, of course, not only just because she is an attorney, but because she's been through the process herself, Sherry Smelly and her friends at Smelly Law Firm can definitely help you out with that. Thank you so much for coming in today.
Thank you for having me.